Welcome to the October 2025 edition of the Essential GovCon Brief. This is episode 15, the podcast from Gordon Reese, where we break down the latest developments in government contracting, from regulatory updates to court decisions that impact how you do business with federal agencies. I'm Patrick Burns, co-chair of the Government Contracts Practice Group, and I'm joined by Jeremy Camacho. We're happy to have him back on the show this month.
Thanks, Patrick. It's great to be back. We got a really strong lineup of topics to cover today.
So this month's episode starts with a long-awaited DoD final rule that formally embeds cybersecurity maturity model certification, CMMC, into the DFARS. We'll walk through what that means for contractors ahead of the November 10th effective date.
And then we'll turn to a bid protest decision involving the IRS, with the court questioning the agency's justification for awarding a sole source bridge contract. It's a good reminder that urgency alone isn't enough to skip competition.
And finally, we'll look at a NASA dispute under a Space Act agreement where the court upheld NASA's termination after a contractor failed to meet milestone payments. Certainly a useful case study as far as how strictly these cooperative research agreements are enforced. So let's get started.
This month, we're starting off with a big one. The Department of Defense's final rule implementing the Cybersecurity Maturity Model Certification, or CMMC, into the Defense Federal Acquisition Regulation Supplement, or the DFARS.
That's right. This rule has been several years in the making, and it's going to fundamentally change how contractors demonstrate cybersecurity compliance. And this was published on September 10th, 2025, and effective within a month from now, on November 10th. The rule formalizes CMMC as a contractual eligibility requirement for defense contractors. So to put this in context, the DoD has been signaling this move for years. Congress directed the DoD back in fiscal year 2020 through the National Defense Authorization Act to establish a consistent framework to verify contractors' protection of controlled unclassified information, or CUI.
And since then, the CMMC has evolved from a voluntary framework into a mandatory certification regime. It's now embedded directly in the DFARS. Under this final rule, contracting officers can't make an award to any offeror that doesn't have a current CMMC status recorded in the Supplier Performance Risk System, better known as SPRS.
Exactly. And that's a major shift from the prior interim rule, providing that contractors could self-attest under the DFARS or the interim rules assessment requirements. But now it's not enough to say you're compliant. You have to have a verified CMMC status in SPRS at or above the level required for this solicitation.
So let's talk about what's actually in the final rule. The CMMC framework has 3 certification levels. Level 1 for basic safeguarding of federal contract information. Level 2 aligned with NIST requirements for controlled unclassified information. And Level 3, which incorporates additional higher level requirements for critical national security systems.
The rule also creates the concept of a conditional CMMC status. And this is an important addition. Contractors seeking Level 2 or 3 certification can hold a conditional status for up to 180 days while working through their plan of action and milestones, or POEM, to close out remaining deficiencies.
That's a practical concession, but it comes with deadlines. If you don't close out those POEMs within that window, you lose eligibility for the award. DoD is making it very clear CMMC certification is an eligibility threshold, not a scored evaluation factor.
And the rule formally updates the corresponding DFARS clause, 252, 204, 7021, for those taking notes at home, which will now appear in solicitations and contracts. The clause identifies the required CMMC level and ties award eligibility directly to the SPRS verification.
Digging into the SPRS a bit more, because that's where a lot of contractors are still confused. The rule requires contractors to maintain a current CMMC status in SPRS and to identify the unique identifiers, or the UIDs, for each information system that processes or transmits federal contract information or contractor unclassified information.
That's right. So DoD wants traceability. These UIDs help verify which systems were assessed and at what level. Contractors need to make sure that those identifiers are accurate and their SPRS records match what was submitted during the assessment process.
And if you're a prime, you're also responsible for verifying that your subcontractors are compliant. The clause has to flow down to all subcontractors handling FCI or CUI. Each subcontractor must post its own CMMC status and affirmation of continuous compliance in SPRS.
That's a big change. It formalizes what many primes were already doing informally. Now it's a contractual obligation.
A few things from the earlier proposal. For instance, it removes the requirement to report every, quote, lapse in information security directly to the contracting officer.
Yes, instead, DoD is sticking with the existing incident report structure under the DFARS provision I referenced earlier, so contractors don't have to file additional notifications for minor issues, but all significant incidents still have to be reported in accordance with the clause.
And the DoD clarified that the rule only applies to systems that handle FCI or CUI. Contracts solely for commercially available off-the-shelf items are explicitly excluded.
It's also worth noting that contracting officers can bilaterally modify existing contracts to incorporate the new CMMC clause, particularly for ongoing programs that involve sensitive data or new task orders issued after the effective date. So let's talk about what contractors need to be doing now to get ready for contracts issued after November 10th.
First, every contractor, whether prime or sub, should conduct a gap analysis against the required CMMC level. Identify where your system security plan diverges from the CMMC practices and map out all the remediation steps.
Next, make sure your SPRS entry is current. That means your self-assessment or certification is posted, your system UIDs are correct, and your affirmation of continuous compliance is up to date.
And if you're not fully compliant yet, take advantage of that conditional status option, but use it wisely. The 180-day window is a grace period, but it mandates genuine remediation.
For prime contractors, oversight of subcontractors will be critical. You'll need to verify each sub certification status to ensure the clause flows down and document that compliance chain. And
finally, a budget accordingly. Achieving certification can mean investing in encryption, endpoint monitoring, incident response, and sometimes third-party assessments. For small businesses, that can be a heavy lift, so start early.
And Jeremy, one of the broader implications here is that CMMC has effectively transitioned from policy to enforceable contract law. So now it's a binding eligibility condition under the DFARS.
Exactly. For years, DoD has been encouraging compliance through self-attestation, but enforcement was inconsistent. This rule changes that. Going forward, you cannot receive an award, or in some cases even submit a viable offer, without a current verified CMMC status in SPRS.
And this will likely have a ripple effect beyond the DoD. Civilian agencies will likely follow suit, at least to some extent. While the DFARS rule is limited to defense contractors, it's likely to inform future cybersecurity clauses in other agencies' procurements as well.
So in our second segment today, we're covering an important bid protest decision that digs into when and how an agency can bypass competition under a limited sources justification, or an LSJ.
That's right. So the case is GovCIO LLC versus United States, recently decided by the Court of Federal Claims. It involves the IRS's award of a sole source scanning as a service bridge contract to Iron Mountain for digitizing incoming tax filings.
What's most interesting here is that the IRS said it needed to skip competition because of an urgent and compelling need. But the court found the agency didn't actually explain why that urgency existed.
So let's start with the basics. A limited sources justification, or LSJ, is a document an agency must prepare when it decides to limit competition. The FAR allows agencies to limit competition only under a few narrow circumstances. First, if there's an urgent and compelling need that makes full competition impractical. Second, if only one source can provide the required supplies or services. Or third, in some cases involving follow-on work where substantial duplication of cost or schedule delay would occur.
And when an agency uses one of those exceptions, the contracting officer must write an LSJ explaining the specific rationale, get the required internal approvals, and for higher value procurements, post it publicly on sam.gov for transparency.
So in this case, IRS had been running pilot programs for years to digitize paper tax filings. Issue what was called a scanning as a service task order to Iron Mountain as a sole source bridge contract. Basically just a stopgap measure to keep scanning operations going while it developed a new competitive solicitation.
Yes, the agency originally intended to justify the award on the ground that only Iron Mountain could perform the work. But then, after an executive order directed the Treasury to move toward electronic payments, the IRS changed its justification. It claimed the order created an urgent and compelling need to accelerate digitization.
The problem was that the administrative record didn't explain how a directive about digital payments, outgoing Treasury transactions, created a sudden emergency for scanning incoming tax returns. The court said that the agency's reasoning just didn't add up.
The judge agreed that agencies can have policy goals and urgency, but they have to show their work. She found that the LSJ lacked a rational connection between the executive order and the sole source award.
And the court emphasized that judicial review is limited to what's actually in the administrative record. While the government's attorneys later offered some compelling arguments to justify the decision, those explanations were not in the record itself, which was fatal to the government's defense.
The judge wrote that while the agency's policy objectives made sense, the record didn't explain how the executive order about payments changed the landscape or accelerated the timeline for scanning paper tax returns. Without that explanation, the LSJ couldn't stand as a rational basis for avoiding competition.
So this case is a reminder that agencies can't rely on post hoc rationalizations. Even if the end goal is good policy, the justification has to be documented at the time that decision is made.
For contractors, there's a couple important lessons here.
So first, if you see a sole source bridge contract on SAM.gov with an LSJ citing urgent and compelling need, that document could be fair game for scrutiny. So the agency has to articulate, as we mentioned earlier, why competition would cause that unacceptable delay, and that reasoning must be evident on the face of the LSJ.
And second, agencies often rely on bridge contracts while planning a follow-on competition. This case shows that even though stopgap awards aren't exempt from the Competition and Contracting Act, and contractors still have standing to protest if the agency's justification just doesn't hold up.
So third, this decision highlights the difference between policy urgency and legal urgency. An executive initiative or modernization doesn't automatically create the kind of urgent and compelling need that justifies skipping competition. The agency still has to show that a competitive process would cause unacceptable delay.
Finally, this is a good reminder that protesters don't always need an injunction to make their point. A remand can still result in meaningful oversight and force an agency to improve its procurement record. So, for our third topic, we're running from cybersecurity and bid protests to a case involving NASA, specifically a dispute over a Space Act agreement and a patent license that went sideways.
That's right. The case is Spectre Corporation versus United States, recently decided by the Court of Federal Claims. And this is a great example of how courts interpret these cooperative R&D and technology transfer agreements with federal agencies, how strictly they enforce the milestone payment and reporting obligations. So here's the overview of the case. NASA's Glenn Research Center entered into two related agreements with Spectre Corporation. One was a Space Act agreement, or SAA. The other was a royalty-bearing patent license for NASA silicon carbide pressure sensor technology.
Under the Space Act agreement, NASA agreed to collaborate with Spectre on research and development to help commercialize the technology. Spectre was responsible for providing advanced funding, over $400K total, in milestone-based installments.
So per the milestones, the SAA said that NASA wouldn't begin work on the next phase until it received full payment for the previous milestone. In other words, the payment was a condition precedent to continued performance.
And that condition ultimately became the central issue in the case. Spectre made most of the payments, but withheld $15,000 from one of the milestone installments, claiming it was dissatisfied with NASA's progress. When NASA didn't receive that payment, it stopped work and allowed the agreement to expire.
So Spectre sued the government, arguing that NASA had breached the SAA and acted in bad faith by halting work and favoring another licensee. It also challenged NASA's termination of the patent license, which required annual progress reports that Spectre did not submit.
Spectre claimed NASA had performed poorly, that it had used outdated equipment, missed deadlines, and even had a bait and switch by supplying older sensor components instead of updated ones.
However, NASA countered that it met its obligations under both agreements, and that delays were consistent with the terms of the SAA, which describe milestone dates as just estimates subject to change upon notice. And additionally, NASA also delivered extra work outside the contract at Spectre's request, essentially trying to accommodate them.
So the question before the court was whether NASA's actions violated the Space Act agreement and whether its termination of the patent license was proper under the contract.
The Court of Federal Claims sided with NASA, holding that SAA's plain language controlled and that advance payment was a prerequisite to continued performance. When Spectre withheld part of its milestone 3 payment, NASA was entitled to stop work. The court also found that NASA had in fact completed the earlier milestone, so there was no basis for Spectre's non-payment. And now another key point is that the SAA specifically said milestones could be adjusted and that performance is subject to the availability of funds. So that meant NASA's modest delays didn't amount to the breach.
And when it comes to the patent license, the court said NASA termination was fully compliant. The license requires annual progress reports, and failure to provide them was a defined ground for termination. NASA gave the required 30-day notice and opportunity to cure, and when Spectre still didn't submit the reports, termination was proper.
So tried to frame NASA's conduct as bad faith, accusing the agency of favoring another licensee and delivering obsolete components. but the court rejected that argument as well.
Yes, the evidence shows that NASA actually went beyond its contractual duties, making early component deliveries and conducting extra work to help Spectre test the technology. The court called those deliveries out of contract accommodations, not proof of deception.
So as for any alleged favoritism, the court said there was no evidence NASA acted with improper motive. The implied duty of good faith and fair dealing, which is a contractual cause of action that's asserted by Spectre, it doesn't give a contractor new rights. It only protects reasonable expectations created by the contract itself. So here, those expectations were clearly defined in the SAA and the license.
Because Spectre failed to meet its payments and reporting obligations, it couldn't claim NASA had frustrated the government simply enforced the terms both parties agreed to.
So for contractors, especially those entering into cooperative research or technology transfer agreements with agencies like NASA, this case carries a few important lessons.
At first, you should treat milestone payments as absolute requirements, not flexible targets. If the agreement says the government's performance depends on advance payment, any shortfall can excuse the agency from continuing work.
And second, timely reporting matters. In this case, failing to submit annual progress reports gave NASA essentially an airtight basis to terminate the license. Administrative compliance, even if it feels routine, is critical.
Third, the court reinforces that bad faith is hard to prove. You need clear evidence of specific intent to harm the contractor, not just dissatisfaction with the agency's performance or a preference for another partner.
And finally, remember that Space Act agreements aren't procurement contracts. They're cooperative R&D agreements, and they're governed largely just by their own terms. So courts interpret them literally, so contractors should negotiate those milestones and conditions carefully at the outset. So that wraps up our October 2025 Essential GovCon Brief, episode 15. This month, we covered a lot of ground, from the DoD CMMC final rule, which makes cybersecurity certification a prerequisite for contract eligibility, to the IRS's limited sources justification case that reminded agencies to document urgency in the record.
And we also discussed the NASA case involving milestone payments under a Space Act agreement, a good example of how courts strictly enforce the plain language of cooperative R&D agreements.
Each of these cases addresses a familiar theme. Compliance, documentation, and transparency are what keeps contractors competitive, whether the issue is cybersecurity, sourcing, or contract performance.
Yeah, the idea is to stay proactive, not reactive. That's where you find success.
And you can find the full written update for October on the Gordon Reed's Practice Group webpage. And be sure to subscribe to the Essential GovCon Brief on Spotify and YouTube so you don't miss the next episode.
Patrick, great discussion as always.
Likewise, Jeremy. Thanks to everyone for tuning in, and we'll see you next month with more updates and insights from the world of government contracting.